Well, welcome to this video. So I'm here today to talk about what's known as the problem of economic loss in the law of negligence. Now, I think the general consensus would be that this has been the biggest problem to face the law of negligence for the last, let's say, 50 years. There's been a lot of ink spilt on this issue, as people say. Lots of journal articles published, lots of chapters in books, whole books published on this issue, lots of cases, lots of toing and froing, lots of back and forward. But what I want to convince you of today, what I want to try and show you is two things. First of all, there is no problem of economic loss. The issue is very, very easily solved, and if you understand the law correctly, so I claim, you'll see that the problem doesn't arise in the first place. That's the first thing. The second thing I'm going to try to convince you of is that you already knew this. You knew this when you were a kid. You knew the solution to the problem when you were a kid. And it's your coming to law that's made you unlearn the solution to the problem. Okay, all right. So that's what I'm going to try and do today. Now, you might say, well, why am I doing this? And there's two ways to take that question. The first way of taking it would be, why do this now? What's the significance of this now? And the answer to that would be, there are a few cases that have come out recently that seem to suggest that all the old ways of doing this, of dealing with this problem, all the old ways of doing the issue of economic loss are mistaken, and that there's a new way, and we need to be switching from the old way to the new way. You can see this approach in two cases from the Supreme Court of Canada, which I'll just quickly cite here, and also a very recent case from the High Court of Australia, which you can find here. Now, all of these cases, all of these citations, I'll be putting in the show notes below, so you don't need to try and copy them out as they flash by. But these three cases, there are others as well, but these three cases are the key ones, I think, that suggest that there is a new way of doing this, a new way of thinking about this. And I want to talk about that new way of thinking about it. Okay, so then why me? Why me rather than somebody else? And the answer is because this new way of thinking about things has been one that I've been promoting for, I don't know, let's say nearly 20 years now. That long, not quite 20 years, but getting there, 20 years. Now, I'm not the first person, I'm certainly not the inventor of this view. The inventor of the view is a professor called Peter Benson, who's a professor of law at the University of Toronto. He's actually happens to be the guy who taught me contract law. He's the guy who deserves the credit for inventing this view, but there are a bunch of other, him and a bunch of others have been promoting this view for, well, the best part of in his case, 3 decades now. And it's really just catching on. So that's why I'm talking about it. I've been banging on about this for 20 years, so maybe I'm an appropriate person to be talking about what the view is. Okay, now, as so often in law, it will help to have a sort of a case in mind, an example in mind that we can use to think about the issues surrounding the problem of economic loss. And what I'm going to do is I'm going to take almost a real case. So the case I'm going to talk about is Spartan Steel, the citation here. Spartan Steel, which is a decision of the Court of Appeal for England and Wales. And I'm not going to deal with the case in all its detail. Maybe I should do another video on that later. I'm just going to simplify the case for our purposes so that it brings out the most important things, the crucial aspects of the case. Okay, so what happened in this case is that the plaintiff is operating a factory. They are producing stainless steel, and in order to do this, they use, amongst other things, they use electricity. They need electricity, and the electricity comes into the factory through a cable in the road that's buried in the street outside the plaintiff's factory. And the defendants, they're doing some work outside the factory, and they cut the cable. So they negligently cut this cable. So as a result, the plaintiff's factory doesn't have electricity for a period of time. It's 14 and a half hours. It takes about 14 and a half hours for them to get the cable fixed. And during this period of time, the plaintiffs are unable to work, right? They're unable to produce any more stainless steel because they don't have electricity. Now, as you'll know, those who've read the case, those who are familiar with the case will know that there's more to the case than this. As I say, this is a simplification, but let's just deal with this. This is the core element in the case that's important for our purposes today. Okay, so a cable is cut, and as a result, the plaintiff is not able to run their factory. They're not able to operate their factory for a period of 14 and a half hours. Okay, and their claim is that, completely understandably, their position is that causes them to suffer loss, right? They had the cable not been cut, they would have been able to work. They would have been able to produce stainless steel for this period, and they would have been able to sell that for profit, and so on. So they've suffered loss. This is what's called in the case loss of profit, right? And that loss is entirely foreseeable, right? And so it seems, according to the basic principles of the law, the plaintiff should be able to recover for that loss. However, as we know, the court by majority said that the plaintiff could not recover that loss, and that's been the position taken. There are some exceptions, but the basic position taken around the common law world is that you wouldn't be able to recover in these circumstances, despite the fact that the plaintiff's loss is entirely foreseeable. Okay, so the question is why? Now, as I say, there has been an enormous amount of ink spilt on this issue. Why is the plaintiff unable to recover? What is the justification, if indeed there is a justification? Now, I'm not going to go through all the history. I'm just going to give you what I think is the solution, the simple solution. And as I say, I think you knew this when you were a kid. So let me just now give you another example. Imagine when you were a kid, let's just say you had a brother called, Billy. You had a brother called Billy, right? And Billy had a toy car, right? And you're both, you love this car. You and Billy love this car. So you play with it all the time. It's one of your favourite toys. Okay, and then I come round to your house one day, and I negligently stand on and destroy the car, right? So I'm just clumsily walking around the place, and I stomp on the car, destroying it. Now, no doubt, both you and Billy are going to be very upset, right, by what I've done. But I think even as a kid, you would have understood that Billy has a claim against me that you don't, right? Billy has a complaint that he can make against me that you don't have. And you can capture this very simply by just imagining that you both, you must say you both run to your parents and you say, "Mum, Dad, Alan just smashed Billy's car." You see, Billy could say, "Mum, Dad, Alan just smashed my car." But you can't say, "Mum, Dad, Alan just smashed my car." You can't say that, right? Because it's not your car. It's Billy's car and not your car. So Billy has a claim against me that you don't, right? And I think, as I say, I think you would have recognised that it just, no one had to teach you this as a child. It's just something you would have recognised as a child. There's a sense in which if we could just stretch the language slightly, maybe you wouldn't have put this way when you were a kid, right? You wouldn't have put it this way, but you would have seen the point of it if someone had put it this way to you when you were a kid. And I've wronged Billy in a way that I haven't wronged you, right? Because I negligently damaged Billy's car, right? But I didn't negligently damage your car. Now, I think if you understand this, you understand how to solve the so-called problem of economic loss. In fact, it's so clear, it's so simple, that you can see that there's not really a problem of economic loss here at all. Billy has a claim against me because it was his car that I destroyed. You don't have a claim against me because it wasn't your car that I destroyed. Now, one of the things that we tend to do in law is we think, oh, yes, okay, maybe that works in the simple sort of case, the domestic case. But when things move into the legal context, they become so much more complicated and sophisticated, right? Well, I don't think they do. I don't think they become any more complicated. And so, well, they just become slightly more sophisticated, as we'll see in a minute, but not very. I think that the simple cases are the ones that we need to learn from, right? We need to stop thinking that the law is oh so incredibly complex and sophisticated. Sometimes the law is actually just simple, right? And I think this is one of the cases in which the law is simple. Think about, translate the kid example, the example of me crushing the car when you're a kid, with Spartan steel. right? In Spartan Steel, the thing that the defendant did is cut the cable, right? Cut this electricity cable. Did that electricity cable belong to the plaintiff? No, it belonged to a third party. It didn't belong to the plaintiff, it belonged to a third party. Okay, so was that a wrong to the plaintiff? No, it was not a wrong to just as in the kid's example, I crushed Billy's car, not your car, and so he has a complaint that you don't have, right? When I cut the cable, the owner of the cable has a complaint against the defendant that the plaintiff doesn't have, right? Because why? Because it's the owner of the cable's cable that's damaged. Okay, now I said just a second ago, in law it's slightly more complicated, but only slightly. In the car example, we're only thinking of property. We're only thinking of who owns the car, whose car is it, right? In law, we have to think a bit more widely than that. We won't say that there can be recovery only if the plaintiff owns the thing that was damaged. We won't say that, but we would say something very, very similar. It's just one step further on. And what is it? It's this. In order to recover, the plaintiff must have a right that was violated by the defendant. Now, in normal cases, in the vast majority of cases, that right will be a property right. Right? So the plaintiff would have to have a property right to the thing that the defendant damaged. But it doesn't have to be like that. It could, at least in principle, be some other right that the plaintiff has that the defendant violated. I mean, for example, right, and this is very common, the right could be a right not to property, but to the plaintiff's own body. So if you cause me personal injury, that's a violation of what we like to call my right to bodily integrity. But it could be some other right? There could be some other right. We have to look around and see if we can find one. But in Spartan Steel, the reason that the plaintiff is unable to recover because they were unable to operate their factory for 14 and a half hours is because their inability to operate their factory was not caused by the violation of any right that the plaintiff held against the defendant. Now we call this kind of loss relational economic loss, and we can now see why we call it relational economic loss, because the loss that the plaintiff suffered was suffered in relation to, or rather as a result of, the violation of a third party's rights. Right? There's no violation of the plaintiff's rights. If there had been a violation of the plaintiff's rights, this wouldn't be a relational economic loss case. But there's no violation of the plaintiff's rights. There's a violation of the third party's rights, and the plaintiff is trying to sort of, as it were, tack its case onto that rights violation. But you can't do that. Right? The reason that there's no recovery is the same reason that you don't have a claim against me in the car case. It's simple. Okay, so on this view, right, there is a simple solution to the so-called problem of economic loss. It's just you just have to remember who has the rights in question, who had the rights to the cable, who had the rights to the car, and once you remember that, the problem just goes away, right? It disappears. The problem of economic loss does not exist. Okay, and that's basically it. I think if you can understand this basic point, you can just see that the last, if I can put it this way, the last 50 years of worrying about the issue of economic loss and the law of negligence has been a waste of time. Okay, now before I finish, there's just 4 things that I want to say that might sort of hint at things that could come in the future. One is, I haven't dealt with what actually happened in Spartan Steel. There's more to, as I've said before, there's more to Spartan Steel than I've talked about, and it may be useful if I go on to describe precisely what happened in Spartan Steel. And as you might well know, there was some recovery in Spartan Steel. And why was there? Why was there recovery for some things and not for others? Maybe it would be useful for me to deal with that. Another issue is that I've talked about the issue of relational economic loss. I haven't talked about what's sometimes called pure economic loss, and in particular, I haven't talked about the line of cases that sort of have their ancestry go back to Hedley, Byrne and Heller, the decision of the House of Lords. Now, I actually think that this solution that we've seen today is a solution to all those problems as well, though there's a it's a little bit more complicated. There's another few wrinkles in that context. So maybe I could deal with those later as well, if that would be useful. Another thing, though, is of a different order is, look, I've suggested that the solution to this is really, really simple. So why did it take so long, right, for it to be discovered? I mean, why didn't this occur to people, 50 years ago when the issue first came to the fore? And I think one of the main reasons is an answer that I've already given, that we don't like simple solutions to problems. We think that solutions should be sophisticated and complex, and if I could put it slightly cynically, they should make us look like we're sophisticated and complicated people, right, when we think of them. But as I said, I think this is all a mistake. The simple solutions should be preferred. I mean, why not? If they're simple, that's a good thing. So that's part of the story. But there's more to the story than this. There's a very deep reason. It's got a lot to do with our legal and political culture, that we think that simple solutions are inappropriate. And it might be worth digging into that in future as well. And this is connected with the last issue that I want to raise here, which is, Peter Benson published this view 30 years ago now. Why has it taken so long for it to catch on? And there is a particular reason why people don't like this decision, right? Don't like this position. They don't like this solution. It's not just that they don't want it to be simple. They don't want there to be a legal solution to the problem. Right? That's one thing to notice about the solution. The solution that I presented is a legal solution to the problem. Right? It just says if you pay attention to the party's legal rights, you'll see that there isn't a problem. People don't want there to be a legal solution to this problem. People are very opposed to the idea that there might be a legal solution to the problem. And that, I think, tells us something very important also about our legal and political culture. And it may be worth getting into that in the future as well. In fact, I hope I will do so. Anyway, I hope this video was useful, was interesting. If obviously I'd love it if you left a comment or a like or something, and to let me know, especially if there are things that you'd like me to cover in future. That would be great. So cheers, all the best.